My name is Marty Shenkman. I'm joined in order of appearance on the screen, Thomas Tietz, Jonathan Blattmachr, Alan Gassman, and Robert Keebler. We're going to talk informally about, we're near year end. Can you squeeze in some planning just before year end? There's some good stuff to do. There are important developments that occurred this year. We'll talk about a few of those. And with all of this, we're going to have an eye on what we should, as planners and estate planners, be talking about to clients in the new year. And I think there's a lot that's changed, and the environment remains dynamic, and we're going to talk about that. And Bob, at some point you should mention, even if it wasn't in what you were going to talk about, portability, and we should all talk about that briefly, because I think that's a big issue as well. So Bob, why don't you kick it off and enlighten us?
Well, Marty, my topic today begins in 1940 in the Second Circuit, Kennan versus the commissioner. And basically in Kennan,
I think it's Keenan, by the way.
Kennan, you're undoubtedly right, Jonathan. So Kennan, we have a pecuniary bequest. So I leave $15 million to my trust. That's a pecuniary bequest, a specific dollar amount. And when you have that, there's a possibility of having a gain upon funding. So if when you died, Apple is worth 100, but when you funded Apple is worth 150, you're going to have a $50 gain on that. Okay. Now, probably most people listening today have heard of this whole case. Okay. And what goes around it. Now, the law behind this is 691A of the code. That's generally where we're starting. But when you get a step up in basis, this problem typically goes away. So I bought Apple for $1. I died when it was at 100. That $99 a gain is forgiven. And then we go back and we look at that. But if it goes to 150 and you fund a bypass trust or a GST exempt trust with a pecuniary amount, you recognize that gain. And if your document already includes that, there may be limited things you can do other than trying to fund with particular stocks or bonds that haven't gone up in value. But recognize the step up in basis makes a lot of that go away. But in a market like we've had this last year, very fascinating, you have some tech stocks that have just jumped enormously. Here's the issue. When you have a Kennan gain, okay, when you have a Kennan gain, you have to recognize that. That's whether you have an estate or whether you have a trust. Now let's distinguish that. If I die and there's a probate estate, I fall under the rules for the taxation of an estate. If I die with a trust, everything's in the trust. I do not make a 645 election. I have a trust. And here's the difference between the two. When you have an estate, you're allowed to net gains and losses when you fund a Kennan bequest, okay, a Kennan type bequest. So, Jonathan, if I had $1 million worth of gains and $1 million worth of losses, they would net with an estate. But with a trust, strangely enough, the way the rules work under 267 is you're not allowed to use the losses to offset the gains. And that's something that every planner should be aware of in a market like this. And the PowerPoint I've attached to this will help, but go back and look at that. If you're a lawyer administering estates, you're welcome to share that PowerPoint with the CPAs who will be doing those returns, but it's something you can get ahead of. And it's the real moral of the story is for a trust officer or a lawyer, work with the CPAs and encourage them to evaluate whether they should make a 645 election, which brings a trust into the world of an estate. Now,
and therefore you can offset the gain by the loss.
Exactly, Jonathan. Exactly. You can net. Otherwise, you're stuck with recognizing the gain and the losses over in the corner, suspended someplace until you can use it in the future. Now, the second thing I want to talk about.
But Bob, can't go on without us asking you questions. You wanted to sneak by me, but that's not happening. So in this environment, Jonathan, while Bob's clients only invest in stocks that go up, I personally prefer stocks that decline in value. Volatility can go both ways. If we have a decline in value, might we, because the market is kind of frothy, if that's an acceptable term to use, and if we see a drop in the market, might we not, for the first time in a long time, start to see people looking at alternate valuation date?
Well, that's certainly a possibility, Marty. And Bob assumed that you really are going to get credit for it at its 150 value, even though your obligation when it arose, the stock was only worth 100. So you would have a $50 gain.
But if the value of the market goes down because, let's say, this AI boom busts, we may have to be careful to look at alternate valuation date, because then we can reduce the value of the estate and save estate tax. Bob, Alan, any thought or comment?
That makes good sense. Bob, when would you not make a 645 election?
Rarely.
Just make it every single time.
I think we'd have to go through Jonathan's book on fiduciary income tax, and there are probably some circumstances where it's enumerated to do that. But I think what my instructions to the CPAs that work with me is 90% of the time we're going to want to make a 645 election.
But keep in mind that the 645 election is for a limited period of time.
Exactly correct. You're on the clock once the estate is administered, and there's some technical requirements in the regulations, then you lose that privilege, okay, and you go back to the taxation of a trust. But certainly up until the closing letter, the funding of the trust, we should be within the provision of the law that allows us to make a 645 election. But touching on alternative valuation, the basic rule, Marty, is 6 months. I'm going to measure it 6 months after somebody dies, but you actually have to incur a tax to make it. It can't be, I die, everything goes down in value, and my wife just gets less in her bypass trust, but there's still no tax. That's not the situation. But sometimes we want to force a tax. I mean, if a stock fell tremendously during that 6 months, you might set up a series of disclaimers or not make a Q-tip election to actually force the tax, especially with a volatile tax. I had it once where the stock was up when they died, down at 6 months, and up again by 9 months. It was the easiest decision in the world what to do.
Yeah, that was the point I'm getting at. I'm concerned. I don't know if you are. Ellen only buys stocks that go up as well, but I'm concerned that we could see some really significant volatility. We all need to be really alert for that, because you have all these different options of what you may want to do, and it could make planning for administration of estates more complex. You had another topic you wanted to talk about, Bob.
Well, the second topic starts in 1998, Roth IRAs. And before we get done with the year, we have to look at Roth IRAs. Now, pretty much everyone talks about the Roth IRA in terms of filling up brackets and converting to a Roth early so you pay less Medicare tax later, and all that very complicated analysis at the bottom of the market but let's go to clients in the top 1 or 2%. Why would they evaluate a Roth IRA? And what I'm going to encourage the estate planning lawyers to do is, I think if you went to most lawyers and said, is looking at a Roth IRA within your province or the province of the CPA, I think a lot of lawyers would say, oh, that's a CPA thing. But I'm going to say not entirely true, because some of these Roth conversions are very strategic from a wealth transfer perspective. And to understand that, you have to understand that sometimes in some states, notably Connecticut, Maryland, Massachusetts, to die with a Roth IRA is much better than to die with a regular IRA. And that's because of the intersection of state and federal income tax and estate tax. The heart of this starts with a section of the Internal Revenue Code, federal law, IRC section 691C. 691C gives you an income tax deduction for estate tax paid. So Jonathan, a client of yours dies in Florida. She has a $10 million IRA, all subject to tax. She leaves it to her sister. You pay $4 million of estate tax. The sister only pays income tax on $6 million, okay? Now, that's very easy, but it gets more complicated when somebody dies in Connecticut or Maryland or Massachusetts, and they're writing out 2 checks for the estate tax, one to the state and one to the federal. And what we're trying to do here, very critical, is we have to recognize, Marty, there's a missing 691C deduction. And the missing 691C deduction means that you cannot deduct the state estate tax when you compute your federal income tax. And in the materials, I show that, but at the end of the day, we call that the missing 691C deduction. And that will generally cause a difference in wealth transfer, literally of over 20%, okay? So that's gonna be a very significant thing. It's to the point where if somebody came in your office tomorrow and said, I'll be dead in 6 months, single person, and they had $1 million IRA, and you were in one of those states, you would actually evaluate doing a Roth conversion in the next 6 months, okay? And a lot goes into that, but it's complicated. Now that's the missing 691C deduction. There's another phenomena mathematically called the fading 691C deduction. Basically, my 691C deduction is frozen on the day I die. But my IRA account is going to grow. And when we run the math on that, we're typically seeing that, again, you're going to have about a 15% difference caused by that fading 691C deduction. But when you combine the missing and the fading with a third phenomena that states like Vermont, Maryland, Connecticut, Massachusetts, California do not give you a state income tax deduction for the estate tax paid. And when all those things lined up, when you're in that worst possible scenario, you actually end up with a Roth conversion will put 30 to 40% more wealth in your children's hands. It's amazing. And what caused us to revisit this was the $15 million exemption, and there's a lot of activity in the financial planner world of who should convert, who shouldn't. And I would just encourage the estate planning lawyers listening to wrap your mind around the strategic benefit of a Roth IRA. Forget the tactical filling up brackets. Those things are all great, but they're not going to move the needle for an estate plan. What moves the needle for an estate plan is my wife and I come to see you. We have $2 million in our IRAs, and we've never really seriously thought about a Roth conversion, but we owe estate tax. We might owe some state estate tax. Then will help us at least start the process of looking at a Roth IRA.
Alan, let me ask you a question about Roth conversions. Apart from the taxes, if you have a Roth conversion and you take X millions of dollars out of an IRA and you put it into a Roth IRA and you're able to pay the income tax from non-retirement assets, isn't that an immediate and great asset protection tool?
That's a really good asset protection tool. It's got a lot of business purpose. Absolutely.
Okay, now, do you want to comment on that? Because I see that overlooked all the time. It almost, to me, when I converted first converted my IRA to a Roth, my financial advisor said, "Oh, I'll do an analysis." I said, "I'm not interested in your analysis. I'm converting because it's going to safeguard assets, and I'm paying the tax with unprotected dollars. So now instead of having, partial dollars in my IRA, I'm going to have full dollars in my Roth."
Right. No, it makes a lot of sense. The Roth is creditor protected, at least in most states, unlimited amounts. And
very important point. You have to check state law. It's not like an ERISA plan that's protected under federal law.
Now, Bob, more and more, I'm finding clients that have a giant Roth and their home and no other assets. Does it make sense to convert when you have to eat part of they have huge IRAs, not Roths, but no other assets? Does it make sense to convert when you're having to eat the IRA to pay the tax?
There's going to be circumstances. Now in Florida, not so much, because no state estate tax and no state income tax.
Right.
But you have to look at, you also have to look at where are the beneficiaries. I just picked up on this. Client lives in Illinois, $20 million IRA, but his son lives in California. And right there, Alan, from a strategic standpoint, if you're the lawyer, you say, wait a minute, if we convert in Illinois, we have no income tax on the Roth conversion.
Mhm.
But the child that receives it in California is going to lose about 13% to state income tax.
Wow.
Now,
When you say
because
the child in California loses to income tax,
when he receives his parents' IRA,
even as a Roth,
no, as a regular
Somebody
IRA.
said it
It's a
wasn't
regular.
Roth.
But if we go to a Roth first, Marty, we avoid that California income tax.
that's huge.
Yeah, if dad took that 20 million, turned it into a Roth over time, he would then, even if he had to pay the tax out of the IRA, like Alan's suggesting for some of his clients, he would lose, let's call it 37% of tax or $7.5 million. He would, but that'd be it. There'd be no more tax when it goes to the child in California.
That's great.
So
Alan, let me, oh, I'm sorry, finish.
no, I'd just be curious to go around and just see if I'm totally misplaced, but I think we've done this is probably on me because I've been one of the leading speakers on this. I've probably done a very bad job of educating the lawyers on when Roth conversions should be evaluated. From a big picture perspective, I'm not talking about filling up the 12% bracket or filling up the 24% bracket. I think everybody understands that. I'm talking about very strategic conversions.
It also makes you wonder whether people in their mid to late 50s and 60s should be pushing a lot of money into qualified retirement plans, which just become IRA traps, right?
Well, that's really true, Alan. One of the real problems with IRAs and qualified plans is that you can't get them out of your estate. The IRS has basically taken the position, and Bob tried to get a ruling on this, but they wouldn't rule, that it's going to basically all be in your estate. You can't make transfers to get it out of your estate. Now, there's a private letter ruling out there which suggests maybe you can, but and I've actually, and I'll offer again to all of you, I'm willing to really test the theory. I'm willing to take a small IRA and transfer it to a grantor trust. Now, the IRS is 85-13 and also in the regs under 1001 say that the grantor still owns the assets that are in a grantor trust. So if I transfer my IRA to a grantor trust, I haven't made a transfer for income tax purposes. But Natalie Choate thinks that the IRS will say you have made a transfer and therefore you'd have immediate taxation and you'd lose the ability to have it grow. Now, I don't think so because the IRS's official position is grantor trusts do not exist. The grantor still owns those assets. And Alan, I'll offer it to you, and I offer it to Marty, I'll offer it to Bob. I'm willing to take an IRA and actually make a transfer to a grantor trust, and we will take the position. In fact, I will take the position that I owe the tax, and then I will file for a claim for refund. And let's see what the service does. Now, when I first talked to Bob about this 5 years ago, it would already be over. The fat lady would have sung by now, Bob, but nobody would take me up on that. Maybe one of you guys will.
I'm glad to help you do it. I'll sign the request for refund. That's
Okay.
a great idea. Has anybody considered doing a synthetic sale like the David Handler type of derivative sales? Saying I'll sell my right to the economic benefit from my IRA to the grantor trust in exchange for a note. That should work also, I would think. And then you don't have to pop the IRA until it's time.
I don't know whether that works or not, Alan. I know
Alan,
that.
have you seen any authority supporting this synthetic sale concept? And can you take a minute and explain it for anyone that doesn't understand it? But have you seen any authorities on it other than his very impressive writings on it?
No, I haven't, but it makes perfect sense to me that I can take an economic right that I have relating to the economic performance of my
Any asset.
my legal practice, my Canadian property that I can't transfer, my IRA, and I could sell the upside in exchange for the downside in a contract. And I've read some of David's contracts, and they're very well written. There's reputable valuation firms willing to value these derivatives. And to me, it makes perfect sense. I don't see why you wouldn't be able to. People are optioning and putting contracts on assets all the time. And, you know, we are a right to, we have the freedom to contract in the United States. So why wouldn't I be able to?
Well, I think you can do it, but the question is, what is the consequence of doing that?
Well, the consequence would be that my grantor trust would have the right to a significant upside in my IRA in exchange for an applicable federal rate long-term note. So if the right to the upside in my IRA, based upon the formula that we craft in a conservative manner, is what a willing buyer would pay $8 million for, then my grantor trust writes me a note for $8 million at the long-term applicable federal rate, and I sign the derivative agreement. And if things go well with my IRA, I owe my grantor trust a lot of money or assets, which I can pay from other assets outside of the IRA. So I think it's a very viable approach.
It's interesting for some of the really huge IRAs that are so nettlesome to deal with.
Mm-hmm.
Alan, can I ask you two questions on IRAs since Bob has brought it up as a topic? First, and I think you were the guy that mentioned it, is instead of converting a Roth, use, and I'm blanking on it, but use the money in the IRA, withdraw it and pay medical expenses and get an offsetting deduction. Wasn't that you who mentioned that?
Yeah, the one thing, and I'm in Florida with a very elderly population, and sometimes you do see a family with $400,000 to $500,000 a year of nursing expenses.
The costs are incredible.
So I think you really need to make sure the client who's converting knows that trading their $1.5 million IRA for $1 million Roth basically reduces what they can spend on medical expenses and nursing home expenses by $500,000 basically, because your medical and nursing expenses are 92.5% deductible for most of these families. So I wouldn't want to be an advisor who has a client run out of money or almost run out of money because they converted. Now, most of the people converting don't have these issues. They've got the nursing home insurance or they have nice mega estates. But for others, this may be a consideration. And, the deteriorating social fabric of insurance and the increasing medical costs continue to floor us all. So just something to make sure you disclose to a client and take into consideration.
Alan, would you think that maybe a couple should get divorced? So if you have, say, one of the spouses who's going into a nursing home and the costs are going to be $300,000 or $400,000 a year, that he could lower his income to the point where he would get a huge deduction for it.
Yeah,
he can only deduct it to the extent of above 7.5% of his adjusted gross income.
and in some states, people do get divorced so that one spouse can go on Medicaid and not be disqualified by the marital assets. And other states, there's waivers and things like that. But
I've seen that. I've seen people that have done that. It's very emotional to do. It's difficult.
Yeah, it's sad.
Alan, let me ask you one other IRA question on conversion. If I convert my IRA to a Roth, I have to pay the income tax. I don't have any choice. I could ask the IRS to forgive me, but they won't. Is that arguably a fraudulent conveyance, or can it not be a fraudulent conveyance because you don't have any choice but to pay the tax, but you did make the affirmative decision to convert? Any thoughts on that? Have you seen anything on that?
No, but because the IRS can reach into my IRA, I don't think that it is a fraudulent conveyance. As long as I have enough assets to pay them, and they'll come and take my IRA away from me. They're a super creditor.
Yeah.
So I wouldn't think so.
Lots of interesting points on an IRA. Let me ask a question to you, Jonathan, that maybe you can speak to, and Alan and Tom or Bob can chime in. I had a discussion with a client this morning that I think is going to become, and is already becoming, a much more common discussion. Client funded a SLAT a number of years ago when the exemption was anticipated to be $3.5 million. And their estate's now $15 million, a little under 15. And he was saying, why do I really want to keep this SLAT? And so what we talked about is the pros and cons and options, which maybe you can discuss and speak to, for getting a basis step up on the assets in the SLAT, because right now with the frothy market, those assets are highly appreciated. And I cautioned him that, it's really hard to anticipate what might happen with changes in the estate tax. And, we briefly talked about creditor protection issues of taking the assets out, although at this point he's been retired for a number of years and he really doesn't have any concerns. But I think this whole dynamic of reevaluating an irrevocable trust plan in light of the exemption, what are your thoughts on that? Because I think that's something that practitioners are going to start to see an awful lot of.
Well, as you know, the tax-free step-up in basis at death is probably the #1 estate planning mechanism to reduce taxes. And now you've got something that in theory is not going to be in the spouse's estate, but there is a way to kind of have your cake and eat it too. And that's to make sure that the spouse who's the beneficiary of the trust has a special power of appointment. And she can exercise that, and she can do it by formula to trigger the Delaware tax trap under section 1041A3. If she has a special power of appointment, but exercises it in such a way to basically continue the trust without regard to where the original SLAT was created, it will be in her estate. And you now get the best of all possible worlds. You don't have to give up asset protection at all because she doesn't have a general power, which could cause it to be subject to the claims of her creditors in a number of states, though not in Alaska. But you can have a special power of appointment and trigger that. And I'm really surprised that more people aren't looking at that option, where you do have assets that you've already transferred to a SLAT or some other trust. And now you say, gee, I wish they were in the estate. Should we terminate the trust and give it to the beneficiary, which is going to cause, at a minimum, questions about asset protection?
Alan, any thoughts on what you would tell a client that's trying to evaluate what to do with an existing irrevocable trust, given the much higher exemption than many had anticipated when they did the planning?
We are inserting quite a few testamentary powers of appointment in favor of creditors of the power holder, exercisable only with the consent of a non-fiduciary. I mean, that's.
But Alan, you again with the Delaware tax trap, you don't even have to go that far.
Can you describe the mechanics of what triggers the Delaware tax?
Yeah. Well, let me give you a little background. There was a family in Delaware, maybe you could guess its name, which didn't want to pay estate tax, but the rule against perpetuity said it could only be held in trust for about 100 years. And that would avoid estate tax. So they got their legislature to put in a rule that, if you had the trust continue after the normal rule against perpetuities, you could go ahead and keep it in trust and not make it subject to estate tax because no one would own it. Well, Congress was not pleased, and it enacted what is now 2041A3, which basically says if you have a non-general power of appointment, but you exercise it in such a manner that that new trust you've created by the exercise of the power can continue without regard to its original start date, then the assets in the trust will be includable in the estate. And that is the Delaware tax trap. And you can read all about that in the April 1988 issue of the Journal of Taxation by an article by Professor Jeff Pinnell and me, where we said, hey, this could be the cat's meow. So it's something that you really should be aware of. Now, if you're in a perpetual jurisdiction, it may be that you can't do it because, you know, the concept of a start date doesn't exist in such a jurisdiction. But if you're in a state that does have a rule against perpetuities, like New York or Florida, I think still has one, right, Alan? You can presumably go ahead and do it. That way you get the best of all possible worlds. You keep asset protection, and yet you're not going to have to worry about creditors coming in at all, but you can trigger the Delaware tax trap to cause a state tax inclusion under 2041A3.
Any other comments from anybody about these conversations we're all going to see more of in 2026 about what to do with irrevocable trusts? Any other comments or thoughts?
I think one of the points to have with clients is they need to look at what their current situation is. Younger clients could have decades of runtime and expected life expectancy. So we don't know what the estate tax rules are going to be several decades from now. We may not even know 3 years from now what they're going to be. So have the conversation of what are the advantages of the trust beyond just estate taxes, asset protection. What if there are children that have mental issues or gambling problem, drug issues? Having these assets in trust, if you bust the trust, you've now taken the assets out of that and it's harder to get it back in. Jonathan always uses his tub of toothpaste analogy for that, which I love. Once you squeeze the assets out of the tub of toothpaste, it's very messy to try and get it back in. For older clients, even if they keep the assets in the trust, maybe you take proactive steps in ways that can help with the basis adjustment. If you have a swap power in an irrevocable trust, maybe you get documentation ready to go to execute that swap power to move cash into the trust. Maybe you get a line of credit ready to go, so if the client doesn't have sufficient cash to swap out for the appreciated assets, they can borrow it right before they die and then execute that swap. So you can help allay the concerns of the client by saying, we're going to talk about this, we're going to have a plan, and it's going to be logical, not just for the estate tax, but for the rest of the goals that you have in your planning.
I think the bottom line on this, it's going to be a very common conversation. It's already starting, but people need to be careful. And one of the things that should be considered, will the trustee do it? And what liability might the trustee face for busting an irrevocable trust? And who gets the money? Let's change gears.
But Marty, again, I want to emphasize that if you use the Delaware tax trap, you're not busting the trust. You can stay in trust. I mean, all you're doing is giving the beneficiary a power to continue the assets in trust. The beneficiary and his or her advisors will determine what's the best thing to do. That's how Jeff and I came up with the notion of using the Delaware tax trap. So the client and the client's advisors could determine what is best, rather than having to go to the trustees or going to lawyers, whatever. Got a power of appointment, exercise it to trigger the trap, which Jeff and I determined probably could be done by formula as well. But that really is something that lawyers should have in their arsenal.
Let's change gears and tackle a very different topic. Tom, there was a case called Gali not so long ago that dealt with probably one of the most common family planning transactions, which is loans. I'm not going to ask anyone on the panel whether they've ever seen a client handle a loan from beginning to end exactly properly, paying all the interest on time and canceling it as appropriate when it's been fully repaid. We're not going to even go there. But why don't you talk about the Gali case? Because there are so many family loans that we all see, and so often they could be falling short of what they need to do.
The Gali case is just the most recent in a long line of cases where the IRS challenged the characterization of a loan, trying to argue that it was in fact a gift. I think back to the seminal case, the Miller case from back in 1996, almost 30 years ago at this point, that gave us the litmus test of considering whether the interfamily transaction could be considered an arm's length transaction. So when the IRS is looking at one of these loans, they're saying if you had two non-related third-party individuals, would they have engaged in the transaction the way that it was structured? So the way that the Gali case and the way that the court reviewed the information in this case just reinforces the kinds of actions that practitioners and our clients need to go through when dealing with these loans. So a couple of points that the court brought up was life expectancy. They mentioned that the mother was 79 and she was making a loan to her son. Well, the length of the loan should be considered when you're making that loan. If you have somebody that's 79 years old, giving a 30-year loan probably wouldn't be a good idea. Do a calculation of life expectancy and try and make the loan for a lesser length than what life expectancy is. Intent to repay. Oh, go ahead, Marty.
Alan, if somebody takes Balance of Nature, would we use a longer life expectancy? You know, those vitamin pills they advertise on TV? Go on, Tom.
I saw that commercial, no doubt.
How about intent to repay? In the IRS's petition, they specifically mentioned and argued that there was no intent or ability to repay on behalf of the son that received this loan. When you're looking at the loan being made between family members, take a look at the borrower. Are they in a solvent position? Are they potentially maybe a doctor that's going through residency that has a significant possibility for high income potential? Find some reasons for why this is a loan that can be serviceable to buttress and support the position that this is in fact a loan. Look at the promissory note itself. What are the provisions that you're putting in there? Are there the kinds of reps and warranties that you would expect to see in a third-party transaction? That adds some legitimacy to the loan itself. I'm actually going to read a quote from the case because this shows exactly the reason why one of the main reasons why the Gali transaction was upheld as a loan. This is directly from the court. Stephen, by contrast, submitted a copy of his mom's bank records showing a transfer of $2.3 million, the note they both signed, his own bank records that show he paid interest to his mom each year, and even his mom's income tax returns that show she reported as interest income. And that's what it really boils down to. They respected the terms of the transaction that they created. They paid the interest on time. The mother reported that interest and paid income taxes on it. That level of legitimacy impressed the court and was part of the main reason why they characterized this as a loan. Now that we're getting near the end of the year, go to your clients that you know that have loans, talk to them, see if they've actually made the interest payments. If they haven't, try and get the interest payment made in the same calendar year with a little bit of interest at the AFR rate to step up to make that good. But if you can get things done the year that it was supposed to be done, it may optically look a little bit better. So consistently talk with your clients and make sure that they're properly reflecting these loans that they're making as loans.
By the way, if you have a loan between a person and a disregarded entity, like a grantor trust, you're not going to want to pay tax on that, but you could still report it, but say, cite to Revenue Ruling 85-13 and say, but this is not taxable interest. And, but I think Tom is right. You have to have some independent evidence that you were really respecting it as a loan.
Let me make a comment as to Bob and Jonathan. Let me pose a little variation of what you just said. Bob earlier made some comments about collaboration between attorneys, estate planners, and accountants. What Tom talked about, if things are not reported properly on the income tax returns, it really can undermine any kind of transaction, a loan, and a lot of other things. And it's incumbent on the attorneys when we do planning to make sure the client's accountant knows what we've done so they know to report it, because clients are not often understanding enough or focused enough on the details to do it. Jonathan, if I have a grantor slat that I set up and the trust makes a loan to one of my kids at no interest, because it's disregarded, is that now that I've made the loan, so we have to impute interest on it?
Well, who created this trust, Marty?
I created a trust for my wife and descendants.
Yeah.
The trust makes a loan to my son to buy a house. Very common transaction.
Okay.
I don't want the trustee, because he's the beneficiary.
Because you're the grantor of the trust, you're deemed to have now made that loan.
So now, because the trust didn't charge fair interest, I have to impute interest income to me, like as a gift. as an income.
That is correct. And you're better off actually paying that interest to show, as Tom was just saying, that, you know, you're respecting it. It's legitimate. You really, really want to do that. And in fact, even if you're not paying the interest because it accrues, I strongly recommend you give additional notes each year to show that you respected it. That makes
Ellen, you were going to say
great
something?
sense.
Howard Zaritsky has a great suggestion. He says you got to pay some interest to prove it's a note. The case law is very favorable to that. So have the client make their first interest payment 30 days after the note is signed, and stay on the client and make sure that they set up the account under the trust and that the trust knows how to make an interest payment to them. And then at least you've got solid evidence that there was interest paid. The other thing that I think is, you know, interesting and it's surprising is that if I loan money to my wife, even though we file a joint return, that is taxable income to her, right?
Maybe not, Alan. There is an old private letter rule from a million years ago where the IRS said that if the husband was paying interest to the wife or the wife was paying interest to the husband, and if they were filing a joint income tax return, the interest was not taxable.
Okay.
Now, again, it's an old private letter ruling. You can't find it in the code, you can't find it in the regs, but you'd at least have a ground to say, hey, because the services position used to be that if a husband and wife file a single tax return, they file a joint tax return, nothing really happens between them. And I've had clients take that position because they didn't want to report taxable interest. But the exception you get that, you know, transactions between a husband and wife, you know, sales under section 1041 are not realization events. There's nothing in there about interest. So, you know, you'd have to do that. But again, there's that old private letter ruling, which you can find. I think it actually goes back to the 1950s, which, and if somebody will pay me a lot of money, I will find it and send it to you guys.
Perfect.
Let me go off on a completely different tangent. It'll be very quick. And Alan, you should comment, and Jonathan, you may want, Tom, you may all want to comment. Bob, I don't know, but if you want to, do. AI is transforming what we do.
It is?
Yeah, it is. I'm
Okay,
shocking
wow.
you, I know.
Yeah.
But my experience is that a lot of our colleagues are really not diving in. And it's quite remarkable what AI can and cannot do. Just as one example that I've not talked about in prior programs, one of the things that I struggled with initially is having AI transcribe meetings and being able to use it. And the transcriptions were awful. I did a webinar with Alan. I had AI transcribe it. I fed the transcript, uploaded the transcript into AI, and I gave a lot of instructions on how to write an article out of that transcript. You can't just say write an article. You have to say it's for sophisticated estate planners, make it in second person, not in first person, et cetera, et cetera, et cetera. And it's incredible how close it gets to a pretty decent draft that you can then work on and get an article done in an hour or two, as opposed to 4 or 5 hours. And we're all going to see more and more ways to do that. Alan, Jonathan, Tom, anyone want to comment?
Well, Alan, I mean, it's very true, Marty, but the question is, why in this webinar did you mention that?
Just because we're looking forward to what happens next year. And the idea is that simply taking something like this can add such incredible efficiency to what we do. So one of the things that we're going to all be engaged in is talking about what clients should be doing with those old irrevocable trusts. You talked about the Delaware tax trap. We talked about other aspects. We talked about Bob with lots of options for Roth conversions. You can take and have a meeting with the client, get a quick transcript, feed it into AI, and for very little cost or time, send a pretty good follow-up letter to a client. It's a great way to generate business and you know, be more efficient. It's how we apply what we do. Anyone want to comment?
I'll just say it's getting smarter and smarter. I had a call with a client today. It was a 45-minute call. They wanted to change their trust. They wanted to appoint an independent trustee, and they wanted to move the trust to the jurisdiction where the independent trustee was. And before the end of the call, I had the draft petition. I had the letter prepared. I had an analysis of the trust, but done by Claude, and then I had it reviewed
Claude's an AI.
Claude's an AI. I had it reviewed by ChatGPT. Claude rewrote it based upon ChatGPT's advice. And during the call with the client, before the client even signed off the call, I had about 8 lawyer hours of work done. Now, I'm going to have to spend 2.5 hours of my own time carefully reviewing that. But instead of 8 hours, it's going to be 2.5 hours. And I don't hesitate to send it to the client after the meeting and saying, at first glance, this looks like what we're doing. Take a look at it. Let me know what you think. It's just AI. You can't trust it, but let me know what you think. If you haven't been at least trying this, you should try it. It's very impressive. You have to be very careful with the secrecy. You have to be very careful where you're doing it, but it is going to leapfrog into something much more powerful than what it was a year ago. So during the holidays, you're with your relatives, you'd rather be doing something else, take out your phone, subscribe to one of these services, and you'll have a great time. The tax research is also very insightful, we're finding, as long as you give it reasonable protocols.
I just to emphasize what Alan said, this is changing so fast, so positively, and getting so much better so quick. All the things we're talking about, when you go out to apply those to clients, try to integrate AI into helping you do all of this. Jonathan, one of the things we chatted when we were talking about the webinar is, I think you phrased it as the importance of continued planning. And, with the high exemptions in the current environment, certainly moderate wealth clients are very hesitant to come back unless something affects what's going on. Maybe you can comment for really all of us for 2026. What kind of things do you recommend we be looking at for clients? Any thoughts on what we should be telling clients? What do we think about for coming into the new year?
Well, Marty, the big, beautiful bill really made a tremendous number of changes. In fact, if you're a CPA like Bob, next year is going to be a bonanza because there are so many changes that have occurred. I mean, I don't know, Bob, whether you're geared up for that, but, just all these changes from Trump savings accounts to the huge changes in charitable donations. In fact, one of the things that I think people on this call might want to do is to consider making some significant charitable gifts this year, because if the bill goes through and they cut back on the benefit of charitable donations, and there's an automatic 0.5% cutback on those, that's right in the law. But there are other things which would suggest that you may wind up basically having a taxable transfer if you give money to charity, say from a trust of over $16,000, or if you're a married couple giving away more than $750,000, you're going to have to wind up reducing that charitable deduction by about 5.5%, which can result in a 2% tax on charitable donations you make. And that's really something that people need to focus on. And in fact, I'm really worried about clients who have charitable lead trusts, big charitable lead trusts, who thought, well, I'm going to avoid the income tax because I'm distributing all of the taxable income of the trust out to charity. Well, beginning next year, if the law is upheld, although I will tell you that Mitch Gans and I have discussed this, and we think that they probably will not enforce it literally. It's just crazy. And in fact, Bob, I don't know if you've looked at this, they even for the distribution deductions under section 651 and 661, it appears that that too will be subject to the haircut. And you wind up paying a tax. I mean, it's just madness. No one really thought this through. Of course, we heard nothing about this until the bill passed, but it's very, very scary, and it's very difficult to know what you should do. But one option really should be to think about making charitable donations this year and not getting caught on that.
Jonathan, I'm sorry to jump in, but I had not heard or thought about the possible application of the 2/37 reduction on, you're saying on a DNI deduction for a trust?
Yeah, I mean, I had
If they did that,
misread
what
it.
would that mean? What would happen? What would you do?
Well, here's what happens. It basically says that under section 68 now, that you get, once you're over the 35% bracket, which for a trust next year is going to be about 16,000, for a married couple, it's going to be about $750,000. You go ahead and you have to reduce your deduction back down to effectively a 35% bracket. That's basically a 5.4% reduction in the amount. Now, a lot of people say, but that can't apply to a distributions deduction under 651 or under 661. Well, guess what? There is a provision under section 67 which says this provision doesn't apply in the case of an estate or trust, but it's only for purposes of 67. It is not for purposes of section 68. So literally, it would mean that if you're, if you've got a huge trust and you're giving away lots of money and the beneficiary is picking it up, maybe the beneficiary is even in a higher bracket, but now you're going to have to wind up basically paying tax on that differential. Now, again,
You say the trust pays tax.
yeah, the trust is going to pay the tax.
Even though it distributed all the income, it's got a tax liability.
That's correct.
That
Same
sounds potentially very problematic.
Same thing for charity. So, when you get into a situation, what do you do if you've given it all away and now you owe money? And do you go back to the distributee and say, hey, you got to give me money back because I owe income tax, even though I gave it all to you or I gave it all to charity? Mitch Gans and I don't think they will literally apply it. And of course, with the current people who are running the IRS, I think there's a reasonable chance they'll do it, but you can't be sure. So it's really something you need to talk to your clients about.
What do you tell them other than saying this could be another mess to deal with?
Let me just run through the numbers, Jonathan, so I make sure I understand this. Let's just say a trust earned $370,000 of interest income. Nice and simple. Forget all the de minimis amounts. There would be a DNI transfer to the beneficiary if you paid all the 370 out. So
Yep.
You're the trustee, I'm the beneficiary, I put 370 on my return. But on your return, you put 370, but you only get a distribution deduction of 350.
Correct.
And you'd have to pay income tax on the 20,000 that was left.
The trust has to.
So if indeed this is an issue, the IRS needs to, in all fairness, tell us this by January 15th, because you as a trustee would want to make your estimated payments.
Well, that's true. And Bob, remember the IRS is going to have to come out with, 1041s here pretty soon. I think they come out like in the fall, at least that's when they have, close to the final draft. But, ACTEC and others have now written to the Treasury and said, hey, you've got to tell us what the rule is here. But I find it almost impossible to believe that they're going to literally enforce this. And there's not going to be anybody who's going to fight with that, even if you say, well, they don't have the authority to do it and nothing is going to get through the Congress to make this a statutory change, which it should be. Nobody is going to fight with the IRS saying, oh, you shouldn't have given this away. You should have imposed income taxes. I mean, it's a very bad situation. Now, I have one thought here, which I will share with you guys. And I've spoken to my co-author, Lad Boyle, of my book on the income taxation of estates and trusts, which, by the way, everyone who's listening should realize that is probably the most thoughtful holiday gift you could give anyone, is a copy of that book. I really mean it.
Jonathan, I was actually giving everyone already in the holiday cards your article with Pinnell on the Delaware tax trap, because I really thought that would be a hot conversation item.
But you really need to think about that. And I'm very, very concerned that, people will not be aware of this. I mean, I don't know what you do if you have a large charitable lead trust and you're distributing out millions of dollars each year, and they say, oh, your 642C deduction is cut back by 5.4%, or you're making distributions to a trust and your deduction is being cut back, so you end up owing federal tax on that. I just can't believe it's going to happen, but literally that could be the result.
An interesting point if you're terminating a trust as well. If there's DNI that's being part of the termination, are we going to have to create refunding agreements for the beneficiaries that are receiving the final distributions from that trust? It's like
Well,
shutting down an estate and having a receipt release and refunding bond.
Well, I've always worried about things like that, Tom, that, that you're going to have to go back to the beneficiaries, because I've always used receipt release and refunding agreements. But, now you can tell them, you really need to keep part of this money aside. Of course, beneficiaries often, are like tax lawyers. They spend what they make. So you give the beneficiary $100,000 and he says, well, I can spend this any way I want, but then you come back saying, no, I need it back. It would be very ugly.
I need to correct you, Jonathan. If you give them 100,000, they're going to spend 105,000.
Right. That's very
Hey,
true.
Bob, Jonathan mentioned Trump accounts. Can you enlighten me, when would I want to care or think about a Trump account? Would somebody not want to max out their 529s first? Maybe just take a couple minutes, even if you want to explain briefly the Trump, and tell us when and why we would care.
Sure. Under the bill, there's a new
Big, beautiful one.
the big beautiful bill. There's a new vehicle called a Trump account. Okay, and I could put, if I had a minor child, I could put $5,000 in there the year they're born up through year 17, total of 18 years. Okay, and all the growth of that would be then available later. He could take the money out later, roll it into a Roth IRA. There's a lot of flexibility there. Great discussions in the financial planning world on whether the go-to is the 529 or the Trump account. My own inclination is the go-to is probably the 529 plan. Fund the 529 plan first. But if you have an ultra high net worth family, the Trump account isn't a bad thing to do. The other thing that's important is the government will give you $1,000 when you set up the Trump account. And that may be worth looking at. I know it's only $1,000, but if you have 3 children, that's $3,000, and you can play with your calculator and figure out what that's worth when they're 18.
One of the things that we do not know, for 529 plans, they said basically that this will qualify for the gift tax annual exclusion. They don't have that for the Trump accounts. Now, again, they think that this may have been a drafting oversight, but it's possible that if you add that $5,000 to your children's Trump accounts, that you're now going to be making a taxable gift, because they will not have immediate access to it. It's not like a crony trust. But, I think that everybody agrees that was just a mistake where they just didn't take adequate time to add that on.
Bob, you said for ultra high net worth clients, a Trump account makes sense. Isn't the funds that come out of a 529 that are used for permissible purposes tax-free? There's no tax, but isn't the money coming out of a Trump account, that growth, taxable? Did I have that wrong?
Right, Marty. No, I think that's exactly right. So you'd fund the 529 first, and then you'd flex to the Trump account.
But Bob, can't you roll the Trump account money into an IRA for the child tax-free?
That's the big thinking, is when the child was, say, 22, that they graduated in May from college and they work half a year. In that year, you'd flip their Trump account into a Roth IRA.
What does the working have to do with that? Why at age 22?
Well, there's some debate on this, but my understanding, and maybe I'm wrong, is that an IRA income is basically considered unearned income and would be subject to the kiddie tax.
So the Trump account, when you take it out, like to turn it into a Roth, is taxable.
Yes, absolutely.
So again, just to
not your basis. If I contributed 90,000 for a child, 5 times 18, and it was worth 200 when I converted, I'd only pay tax on 110.
But it's not you, it's the child paying the tax.
The child will only pay tax on 110.
So it sounds like the broader plan is max out what's reasonable in a 529 plan, then fund a Trump account, and when the kid is of age, convert the Trump account into a Roth.
I think I'd modify that a little bit. Set up a Trump account with, say, $100 and get your $1,000 from the government. Then do your 529 and then backfill on the Trump account.
Now, by the way, there's been virtually no publicity.
Everything is so simple, isn't it?
There's been virtually no publicity from banks and stuff on this, but I think you'll begin to see it next year. I think that the banks will begin to advertise, hey, come in and, you get this extra $1,000 and, we'll set up, it's like, what are they, Christmas accounts people used to have, where you put money aside every week so you had some money for Christmas presents in December. And I think that the banks will push on that. That's my guess.
No, I think that was very helpful, Bob, because a lot of people don't understand the need for it, but I think and Jonathan's probably right, we're going to hear more and more about it. We're all going to start to get questions asked, especially, I think there's something, even if it's only $1,000, clients are going to want that. Wow, the government, I can get money out of the government. That's kind of got its own appeal. Tom, we only have like 5 minutes. Do you want to just take a minute or two and talk about maybe one other relevant case or important case last year, and then we'll comment on that and see if anyone has anything else to wrap up.
And I'll tie it into another point that Bob wanted to bring up, which is portability. We had this summer the Rowland case come out, which dealt with a failure to properly file an estate tax return and the loss of a dissue under portability. In that case, the wife passed away first. They filed an estate tax return late, so they had to file it under the revenue procedure for just portability purposes to file, but they did not include enough valuation information on the assets that were in the wife's estate. There's a lot that I'm not going to go through here, but there was 3 exemptions down that they fought to try to say that they didn't need to give that information, but the court found that unless you have a complete and properly prepared return, they're not going to allow the dissue. Now, this was a family that faced an estate tax on the second spouse to pass. This was a loss of about $4.5 million of portability dissue. That cost them about $1.5 million for the family because they didn't take the time to properly do an appraisal for the various entities and assets that they had and listed on the estate tax return. Not a good result for the family. And Bob, I think you had a couple things you want to talk about portability as well.
Portability is, we continue to miss portability returns. Not a week goes by where I do not get a call on somebody that missed one. And last week's tale of woe starts in 2013 when the gentleman died, and worth he and his wife were worth $28 million at the time of his death back in 13. And this happened on the East Coast. They went to see their lawyer, and the lawyer did not advise them to file for portability. Okay, so because they were over the exemption amount, Tom, there's no fixing that. I even reached out and I knew what the answer was. I knew there was no fixing it. I even reached out to the service and said, have you rethought this? Is there any way we can work through this? If you're above the exemption when you die, you cannot file this by sending a late return, even through the PLR process. So we really have to be all over this. Now, the heart of this problem, the lawyer probably made a mistake, okay? But the account was joint with a national named financial planning firm. And we'll see how this plays out in litigation, but I certainly had to suggest to the malpractice attorney, you need to raise the question of whether the certified financial planner at XYZ should have been saying, referring it to a CPA or lawyer to look at portability. And that's a scary expansion of the scope of practice. But what we're seeing all over the United States is the financial advisors are practicing differently than they did 10 or 15 years ago.
And even a few years ago.
Even a few years ago, to some extent, boxing out. There's a lot sharper elbows than there ever were, and they're boxing out the lawyers and accountants, and that's not a good thing. And part of why that's happening is the pressure they're feeling to be holistic, and part of what's enabling them to do that is a twofold issue of the shortage of CPAs, coupled with very broad use of AI. And I think it's important for all of us to remember AI in the hands of a dentist practicing dentistry is brilliant. In the hands of an architect trying to figure out how to design a building, also brilliant. But when you start crossing professions, that's not a good thing.
It's a big and very significant issue. I think having financial advisors taking a proactive role in estate planning is a powerful thing for them, the clients, and us when it's done well. When people are taking steps beyond their swim lane and their knowledge base, which is very different because we know financial planning firms and trust companies that have some of the most brilliant minds in the country on estate planning, but are they actually involved with the clients? And we all know other firms where they have very limited expertise, and having taken a few courses in estate planning can help you be conversant, but never equip you to really make these decisions. We're facing an exact situation like you described, where a client passed away and the financial firm moved all the assets before we even knew that the client died. And it's not a good result. I think that what you're saying is really the going to be another trend in the planning. Not only more financial planners being involved in estate planning, but more financial planners being involved in suits and claims when that planning was done inappropriately because they didn't reach out. So I guess good and bad in both of it, and we'll see how it shakes out. Alan, any other thoughts on what we might see in the coming year and what we want to do in the coming year?
Well, I think we need to know our qualified opportunity zone rules. We need to know our Section 179 rules. There's still people who could spend 100 hours buying an airplane or a charter boat before the end of the year, putting it in place. For business only, charter it once to an arm's length third party and deduct the entire cost of that asset. Maybe there's not time this year yet at this point, but there will be time next year. There are a lot of income tax planning opportunities under that big, beautiful bill that we can spend our time getting our arms around.
One last question and then we'll wrap. We've all talked on lots of other programs about the potential benefits of non-grantor trusts. Have any of you seen a lot of this starting to happen? Do you anticipate us seeing a lot more of it next year? Thoughts, comments, and then we'll wrap up.
I think it's going to take a moment, and most of this will be the lawyers that are meeting people every day, helping them with their estate plans, seeing the opportunity. Okay, so anybody worth less than $30 million. I come into Alan's office with $30 million of cash. It's a fairly, and I'm 92 years old, my wife's 92. It's not an overly complicated plan because we just have to keep an eye on that 30 to make sure it doesn't go up where there'd be an estate tax. But
or they don't live in a state with an independent estate tax.
Or they don't live in a state with an independent estate tax. But then I say to you, Alan, is there anything we can do to save income tax? And you might say, well, sure. Let's talk about if we can set up some non-grantor trusts for your children and grandchildren, get income off of your income statement onto your family's income statements, plural. And that's really what that's going to be about. We taught a lot of this, but surprisingly, it hasn't caught fire as quickly as I thought it would. But maybe once people start catching up on their backlog, remember, this was only July 4th. So we haven't even gone 6 months. And people still have a good backlog of 706 work, planning that was in place, the state administrations. When we slow down a little bit with new people coming in that don't need as much help, I have a balance sheet on my desk right now for a gentleman worth $29.5 million. Normally, if the exemption was 15 between he and his wife, that would have been a ton of work for us. But at 30 million, I'm just doing a fatal flaw review on the documents his ag tech lawyer drafted. His lawyer's wonderful. I don't need to do a lot of extra work there.
Bob, I think one of the things, and I'm going to say for lawyers what I kind of just said for financial advisors, Alan just talked about a whole bunch of income tax planning, but Alan is, I think, different than many of our colleagues because many of us don't have significant income tax background or didn't have an accounting degree or an MBA. And what estate planners have to do is realize that there are so many income tax planning options that can be interrelated or involved in the estate planning. Just like I said, financial advisors need to reach out when they're beyond their swim lane. Estate planning attorneys that don't have the income tax background, they need to collaborate more with their accountants so they can get the knowledge to be able to bring the non-grantor trust and other planning to their clients. Jonathan, why don't you, we're out of time, we're going to wrap up. Why don't you make any closing comments you want, and then we'll see if anyone has anything to add to whatever you say.
No, I'm going to pass, Marty. I think we've said enough for folks.
You think they have enough to talk about over the holiday
Oh,
parties?
my Lord. My Lord.
Alan, any last words of wisdom?
No, all good. I mean, we're just lucky to be in a fantastic profession where we can help a lot of people. It's intellectually stimulating and creativity pays a lot. So let's keep it up. Thanks for your leadership, Marty. Thanks for your leadership, Jonathan. Thanks for your leadership, Bob. Tom, thanks for doing all the work. And looking forward to the next webinar.
And Jonathan, I again repeat that everyone should buy your book on income taxation of trusts. It's a wonderful holiday gift, and maybe you'll come out with a version that will be colored to look prettier under the tree.
Yeah.
All right, thank you everybody, and we appreciate your patience and especially listening to a program. Really, it's on the cusp of holiday time. Wishing everyone a happy, healthy, meaningful holiday season and a healthy and happy new year, and hopefully we'll see better things happen for the world in the coming year. Be well, everybody.
Take care.
Thank you, everyone.